Uh, okay, we're live. Hello, everyone. Good afternoon. Thank you for joining us here today for the NUJ's Legal Aid Society's lecture series, and this is the second part of the lecture series. This lecture series is on environmental policy making and justice, and it is titled Reimagining Environmental Policy Making in India in terms of empathy, resilience, and intersectionality. So today we have with us a very special guest. And before I go ahead with introducing her and what she will be speaking about, I would be very briefly touching upon what the idea behind this lecture series was essentially. So almost a month ago, we decided that we needed to do this lecture series for one very particular reason, which was that the current legislative and media atmosphere relating to environmental legislations and environmental decision making was being extremely problematic, uh, right from the draft environmental impact assessment bill to coal privatization to the very shady draft national fisheries policy. And the common thread between all these decisions and legislations was that in their neoliberal agenda of promoting development, these decisions were being extremely exclusionary of the marginalized and stakeholder communities, and the communities which had the most to lose and the most to gain from these decisions. So, the goal of the lecture series, in many ways, is to bring environmental policy making in this country in terms of being considerate towards the interests of these stakeholder communities as a whole, and to create a system which is empathetic towards these communities, which is resilient on the face of legislative assault, and simultaneously recognizes that environmental activism is not something which works in isolation, but something which works in relation to, say, tribal rights activism or feminism or other sorts of social justice movements, and it is essentially intersectional in that nature. So in that context, today's lecture is especially very important. Today we will be very exhaustively looking into the controversial and extremely important Godavarman case, which is E. Godavarman Thanumul Pad versus Union of India, which was a case which started in the Supreme Court in 1995. And this case was extremely significant because it attempted to provide a definition of what a forest is. It simultaneously tried to attach a monetary value to forest areas, and really ended up muddling the already complex relationships that the stakeholder communities had with respect to their natural resources and forests. So, delivering this lecture and joining us here today on this afternoon is a very special guest. So, Manju Menon is currently a senior fellow at Center for Policy Research, and she's also an advisory member of the Environmental Justice Program of Namati, which is an international NGO dedicated to legal empowerment. In partnership with civil society groups and governments, Namati implements and evaluates new models for decentralized resource governance and environmental compliance. Her areas of work are environmental law and lawmaking and implementation processes related to the sitting and regulation of infrastructure projects. She has investigated these processes in the context of hydropower, coal, and nuclear power projects. And in the pursuance of her goals, she has written a lot of research papers and articles for the same. Ma'am was awarded the Nehru Fulbright Professional and Research Fellowship in 2011 to study at the Anthropology Department of Yale University, and has been a member of Kalpavriksh, which is an environment research group since 2000. So now I would like to welcome ma'am to join us and provide her knowledge and share her knowledge with us over the course of the next hour. Thank you.
Hi, thank you so much for inviting me to this lecture series. I hope all of you can hear me well. Um, I was, I'm sort of grateful for the way this lecture series has actually been framed. It has all the right words in the title, and we need all of this if we want to make environmental policies in a sensible way, which looks at both social justice and environmental justice in the world. So I'm happy that Shishovan's already mentioned a whole lot of things that I would have had to make, statements that I would have had to make as the opening remarks. So I will get down straight to the lecture, um, the content of the lecture. So what I was keen on discussing, and Shushovan is absolutely right that this we are talking about these issues in a context where there's a great deal of upheaval in terms of what people and governments are both making of environmental laws and policies, in the way they understand it, in the way they want it implemented, and in the way they see the outcomes of these environmental laws and policies. And so in that context, I wanted to discuss a particular theoretical framing with all of you, which is the concept of neoliberal natures. Basically, this has been a sort of a theoretical framing that has been adopted by a large number of scholars, basically, who work on political ecology. And they use this framing to basically understand a whole range of new policies, institutions, and practices of environmental management that have evolved in different parts of the world in the last couple of decades. And they basically try to understand these new forms of environmental management regimes, which involve two aspects. One is it involves the commodification of nature, or turning natural entities into commodities that can actually then be used in capitalist production. So this could be forests, this could be water, and a whole range of other natural entities. So that's one part of what these policies and practices try to do. But the other part, which is equally interesting, is about how these new policies and practices actually create new kinds of natures. They create these new kinds of natures which are quite peculiar in their forms. And more importantly, these new natures are supposed to perform certain kinds of functions which are seen as critical for human society. So they are certainly seen as new natures which are completely in the service of human societies, or better still, which are in the service of economies. So I want to look at both these aspects, which and the Godavarman case and the specific cases that I'm going to discuss in the whole range of the Godavarman case or the forest case is actually very useful to understand the production of neoliberal natures. So I'm sure all of you know already about some details about the Godavarman case. It was basically a petition that was filed in 1995 by a gentleman called T.N. Godavarman Tirmalpad of Kerala. And he was basically passing by a region in the Nilgiris, and he saw a lot of timber felling that was going on in that area. And the timber felling was going on in a region that originally belonged to his family. So he was from a princely family of Kerala, and these forests had been part of the family estates, and they had been taken over by the state government in the 1960s, when Kerala was going through the land reforms and the abolition of tenancy. So this is basically how the case started. And as Shushovan said, one of the most sweeping changes that this case brought about right at the beginning, is to actually expand the definition of the meaning of forest, the definition of forest. Basically, what the Supreme Court said is that forests would no longer be only those lands which were under the jurisdiction of the forest department, but it would actually be what we understand popularly in terms of the definition of in terms of the dictionary meaning of forests. So basically, the idea of forests expanded, and the Supreme Court also said that all the state governments are actually supposed to identify what these new forests are as per this new definition, and until then, these forests would be considered as deemed forests. And this is a process that has still not been completed in many states. But nevertheless, it was obviously a very sort of a very unexpected outcome of Mr. Thirumalpad's petition. And he himself has been quoted speaking to journalists saying, "Even I was taken by surprise at the sweep of the judgment. There was quite a hullabaloo about the judgment. Small growers, planters, factory workers, and laypersons from Ooty came up with petitions against the stay order because the Supreme Court had stayed the timber felling in these areas. I began to feel that I had bitten off more than I could chew." Nambiar, who was his lawyer, who was representing him in this case, Nambiar then assured me that the Supreme Court had taken over the matter as its own. And he goes on to describe the initial scenes in the courtroom where over 2,000 people were actually standing in the court because they didn't know how their fates would be changed by what the judges uttered. And from then on, as the Godavarman case became a large sort of case that touched upon every aspect of forest governance, the bench in the Supreme Court, which came to be known as the Green Bench, sat to hear these matters at 2 p.m. every Friday afternoon. And since then, more than 1,000 IAs, interlocutory applications, have been filed in this case, which touch upon a large variety of issues that concern forest governance. Yeah. Now, these sweeping changes that the Godavarman case has brought about has touched regions in many different ways. Like, for example, the Northeast was greatly transformed. The economy of the Northeast was greatly transformed because of the orders and judgments of the Godavarman case. So were sectors, projects, and a whole bunch of procedures. Yeah. So this was an overarching case, and its importance in forest governance and land governance actually can just not be underestimated. And there were lots of different reactions to this kind of a large case that the Supreme Court just took on its own, and these were both positive and somewhat critical of what the court was trying to do. Like, for example, one set of authors write, "Several northeastern states where forests were being plundered by gangs and unregulated sawmills operated openly were rattled. A ban on movement of illicit timber was imposed. 94 wagons, railway wagons, of illicitly transported timber were seized." This was almost like the initial reaction to the Godavarman case. But then there were others who were quite critical about what the court was trying to do. One of them is Professor Armin Rosenkrantz, who I think spoke at the earlier, presented the first lecture in the series. He said this was a breach of constitutional boundaries. Another scholar has said that this is Nupur Chaudhary, has said that the Godavarman case is a good case to understand how the judiciary shifted from judicial activism to judicial adventurism. Basically, what she's pointing to is that the Supreme Court took on such a huge task of dealing with various aspects of forest governance, but without the necessary institutional support that may have been needed. Basically, while she was writing this paper in 2014, there had already been 4 amicuses that who had helped the Supreme Court in this case, and the Central Empowered Committee, which was a very specialized committee that was set up to help the court in the Godavarman case. Now, she also writes that the Central Empowered Committee basically functioned as a court of first instance, as well as a supervisor of the enforcement of the court's orders. Yeah. Now, the composition of the CEC is important to bear in mind. It's the Central Empowered Committee, the CEC. It was made up of a retired senior bureaucrat from the Environment Ministry. There was one nominee from the Environment Ministry. There were two wildlife conservationists and one serving forest officer who was also the member secretary of the committee. Now, this is what, it's with these people that the Supreme Court took on this massive case of revising and altering the forest management aspects in India. Now, I want to only pay attention to one particular aspect of the Godavarman case because there are so many interesting facets about this case. But for today, we'll just focus on one particular aspect, and that has to do with this idea of compensatory afforestation and the net present value. As Shushovan's already stated, many of you would know what these terms mean, but I'm just going to give you a certain context in which all of this was discussed. So, as most of you would know, India got the Forest Conservation Act in 1980. And basically, this legislation puts across a set of procedures about what needs to be done if forest land or forests are to be transferred for any non-forest purpose. Now, what the law means by non-forest purpose are a whole set of things. It could be things like commercial plantations, like tea and coffee plantations or any other kind. It could also be the grant of private leases on forest land. And we'll come to the significance of that later. And the third aspect is a whole number of projects that may have to be located in forest land or which may require forests in various purposes, like, for example, mining projects and dam projects. Now, this legislation was actually a follow-up of an earlier action of the central government, which is, I think most of you know it by now. It is the inclusion of the term forests in the concurrent list, which is in the 7th schedule of the Constitution. Now, before this introduction, forests were not part of any of the lists. But with the introduction of forests in the concurrent list in 1976, and this happened in the emergency, both central governments and state governments had to play certain roles in order to manage forest resources in India. Now, until that was done, forests were basically managed at the level of the state governments. And basically, state governments were involved in using forests for a lot of different purposes. One, of course, is to set up a whole bunch of commercial plantations. And India has a very interesting history of using forests for commercial plantations between the 1960s and the 1980s. This was actually one of the biggest ways in which the forest departments earned revenue through the use of forests. So many of the state governments were actually engaged in using their forest resources to raise commercial plantations. But there was also, the state governments were also necessarily had to do another important role, which is to look at the multiple claims there were on forest lands. And the reason why these multiple claims existed is because forests are a very contested resource in India. Forests were very important to how the British colonial government set up activities in forest areas and used these forest resources to establish a colonial economy. And because of that, and because we had continued some of those legacies and we had continued to use some of those legislations even after independence, there were a whole bunch of rights and claims that had to be set right in forest areas. And so state governments were necessarily in charge of performing that role. And so if you look at different states, there are waves of activities like regularization of people living in forest areas, the grant of pattas to people living in forest areas. Much of that actually, a lot of critical scholarship says that much of that actually happened only on paper. And the people who actually made these claims and who deserved them did not get it, especially the communities who did not get what they deserved were the Adivasis and other marginalized communities. So the state governments were actually actively performing these roles. And when the Forest Conservation Act was promulgated, basically the central government stated that before forests are transferred for any other purposes other than forestry, the state governments would have to take a prior approval from the central government. And that prior approval involved a particular condition, which is that for every hectare of forest that is transferred for non-forest purposes, the user agency, which is usually the state government, would have to provide an equal amount of land to the forest department and would have to get it afforested. So this was basically a very simple, a sort of a seemingly simple exercise that the central government was expecting all approvals, proposals for forest diversion that were coming to them to comply with. Basically, they were asked, the central government, the Forest Conservation Act basically said that you have to basically offset the loss of forests for certain purposes by bringing in an equal amount of land under forests. Now that proved way more difficult than what the law expected people to do, and so gradually, initially the law expected the user agency to substitute an equal amount of forest that was lost to a project or for some other purpose with an equal amount of private land. But that was very difficult to do. And so gradually the law allowed for public revenue land to be brought under compensatory afforestation. Even that seemed very difficult to do because one, public lands were under a great deal of stress because by then there were a large number of people in India who were landless because of the way the land reforms had or had not been done, and so there were always multiple claimants to these lands, which we call common lands. But on the institutional side, there was also the problem that revenue departments did not want to hand over land to forest departments. So there was that interinstitutional, interdepartmental problem also that was playing out. As a result of which, they had to necessarily, the Forest Conservation Act had to necessarily state that compensatory afforestation would be done on degraded forest land, which was under the jurisdiction of the forest department, and the forest department would just find appropriate places where they could undertake compensatory afforestation, which is basically plantations, to offset the loss of the forests that were going away for various kinds of projects. Now, I mean, this was all fine as a mechanism, but on the ground, the story was completely different. What I'm talking about, all of these changes in regulations in the 1980s, but by the early 1990s, it became quite clear that compensatory afforestation was a big failure, and it wasn't actually taking place at all. What happened in 1996, once the Godavarman case started off, is that the Supreme Court got interested in this particular matter of the failure of compensatory afforestation. Initially, this matter was brought to the notice of the Supreme Court through specific projects, and the initial projects were mostly mining projects, which had, for some reason or the other, not being able to do compensatory afforestations to offset the forest loss because of these mining projects. So what initially started off as a discussion about the compliance of particular projects to the Forest Conservation Act ended up becoming a huge systematic policy matter that the Supreme Court was looking at. In fact, in 2000, the Additional Solicitor General submitted a report on the status of compensatory afforestation all across the country. And his report basically showed that there was a huge shortfall in the compensatory afforestation that was taken up at a nationwide scale. So this obviously became a big issue that the Godavarman case, the CEC, and the Supreme Court actually worked on and tried to find a solution to. The set of solutions involved three sets of things. One is a system to try and look at how compensatory afforestation is actually implemented. And for implementation, there is a need for funds. And so there was this question of how state governments who had already received money for doing compensatory afforestation for various projects, how were they actually spending these funds? That was one of the big issues that got the attention of the Supreme Court. The other was on the question of how compensatory afforestation, when lands are given to projects, they are not expected to pay very much for these forest lands. At that time, the payment that forest users had to make for this diversion of forests was somewhere to the extent of 20,000 to 45,000 rupees per hectare. Now, the CEC felt that this was a really low, this was pitched very low, and it did not take care of it did not provide enough to take care of the forest resource that was being lost. And so they discussed what is called the net present value, and I'll come to that in a bit. So that was the second part that the Supreme Court looked at. And the third aspect that the Supreme Court looked at is that if compensatory afforestation and net present value is all leading to the collection of a large amount of funds, then it would be necessary to have a good institutional mechanism that actually manages and administers the fund in a responsible way. So the third thing that this case did is to actually set up an administrative mechanism for this fund collection and dispersal. Now, coming back to the point about the net present value, basically what the net present value tries to do is that when forests are lost, let's say there's a mining project that is set up and the forest has to be cleared to establish the mining project, compensatory afforestation, which was already a requirement under the Forest Conservation Act, basically said that if X amount of hectares were being used by the mine, then an X amount of land would be turned into forest somewhere else. And if private forest or public revenue for land is not available for that, then 2x amount of degraded forest land would be used for compensatory afforestation. But obviously, when you start doing compensatory afforestation, what you have lost is a fully grown forest, and what you have just planted in the compensatory afforestation plots are little saplings. Now, that is going to take a good amount of time to become a forest and to actually perform the same functions, supposedly, as the forest that you've lost. And so what the net present value tried to do is to put a value on the services that are lost for that time period between the saplings growing to a full forest, the services, the environmental services that are lost to society because of that loss of forests and until new forests are generated, that was monetized in the form of net present value. I hope I hope this is clear. So basically, in the words of the amicus curiae, basically what they were moving by adopting a system of net present value, what the Supreme Court was doing was to help shift from a system which only looked at a restorative value of forests to actually also include a regenerative value of forests. Basically, what is the cost, total cost of regenerating a new forest is what the net present value tried to account for. Now, so through discussions and a lot of discussions in court, what finally ended up becoming net present value is depending on which grade of forest is being lost, forest users would have to pay an NPV of somewhere between 4 lakhs per hectare to an upper limit of 10 lakhs per hectare. So 4 lakhs for poor quality forests and the upper limit for the best quality of forests. So this is how the value of forests changed from the system where compensatory afforestation was charging certain amounts of certain funds from forest users to what the net present value brought it to. And it's interesting that the CEC and the courts were very taken by some of the discussions on environmental economics that were taking place at that point of time. And it applied those principles, especially this idea of payment of ecosystem services, which is a field in itself now because there's lots of scholarly work taking place and lots of people applying it to specific projects. What the court did was to take these principles that were growing in the field of environmental economics and apply it in a narrow way to what they were discussing in the court. Like, for example, so if one wants to understand where this is coming from, the field developed in the US and the UK in the context of neoliberalism in the West. David Pearce was one of the leading academic experts in the field who advised the UK's Secretary of State for Environment, Chris Patten, in 1989 on, and this is in quotes, how to reconcile the market principles of Thatcherism with the newly expressed concern for the environment. So these were some of the interesting principles that the court was trying to put in practice by discussing net present value. David Pearce's 1989 book, it's called Blueprint for a Green Economy. It is one of the highest selling publications in the field of environmental economics. And a lot of scholars have written about these principles and these approaches in environmental economics. The concept of environmental services aimed to bridge ecology, society, and economics. Though used as a term in the 1980s, it was only after 2000s that it got incorporated into environmental policies. And it got incorporated into environmental policies even though its usage was fraught with conceptual differences over its definitions, its principles, and its measurements. So that debate is still raging on in environmental economics about how should one value forests or natural resources, and what would be the ultimate objective of valuing natural resources in monetary terms. Now, there were no doubts in the court's mind about applying these approaches to understanding how forests should be valued. But one of the questions that the court was interested in is how should the NPV be charged in a country like India, where there are different kinds of forests and different kinds of geographies where forests exist. So the court appointed Dr. Kanchan Chopra as the head of a committee. Kanchan Chopra is an environmental economist who has done a lot of work on valuation of natural resources like biodiversity. And this committee articulated that NPV should be a compensation that is payable to stakeholders, not the government, payable to stakeholders for diverting forest land for non-forest uses. The committee submitted its report to the Supreme Court after 5 regional consultations and also sought input from various experts in different fields, especially ecologists. And this report was submitted to the government in 2006. And it tried to look at the various parameters, definitions, and methodologies that would be needed to do something as complex as forest valuation. Now, what the Kanchan Chopra committee did was to recommend a 12-step process. Okay, and that involved very important things like identifying the existing claim of rights, privileges, and concessions of forest-dependent people. It also included a classification of the different kinds of products and services that should be valued while doing forest valuation, like timber, carbon storage, and various other aspects. And it also, the final step proposed was the manner in which the compensation should be calculated. Yeah, one of the important things that the Kanchan Chopra committee report said is that public hearings should be held in every case so that the intention to divert a forest is made transparent by the forest department to all concerned. Yeah, actually, so even though the Kanchan Chopra committee report makes very interesting reading to see it as a counterpoint to what the Central Empowered Committee was stating to the courts. Yeah, that's the only alternative view that the Supreme Court got on this matter of forest valuation. Now, the CEC finally selectively used some parts of the report, and the NPV that was accepted by the court finally was to be based on 7 types of goods and services that may be lost due to diversions, 7 specific types. And the NPV would also include ecological services of forests like carbon sequestration, and the value of flagship forest species were also the parameters that the NPV would include. Now, the NPV has been adopted as a part of the Forest Conservation Act, and is being applied to various kinds of forest users who require the diversion of forest land to be done for their projects. And as of today, a centralized fund that collects compensatory afforestation funds, net present value, and various other funds that come from the penalties imposed by the Forest Department on forest users, all of that stands at over 90,000 crores. Now, I mean, there are a whole bunch of critiques that exist about what this means for forest governance and what this has actually resulted in many forest areas. One of the things that is very important to understand is that this kind of thinking on forest governance actually basically created a new set of relationships between users of forests and the forests themselves, because it completely changed the terms and conditions of accessing these forests. Yeah. Now, these judicial actions basically expanded the reach of capital into India's forests. It sanctioned greater appropriation of forest commons for capitalistic extractive uses. And at the same time, it deepened socio-environmental inequalities by ignoring the complex web of historical claims over India's forests. Now, another aspect which is absolutely crucial to this discussion is how an authority a centralized authority was set up for the management of these funds, and it's initially it was set up through a notification, and then it took several years, and it was this administrative setup institution, both of the authority and of the procedures by which the fund would be administered, were finally given statutory recognition in 2016. That is an entirely it's a distinct and very interesting story in itself. I won't go into that right now, but what I basically want to say about it is that the Godavarman case resulted in the reworking of existing institutions as their roles and procedures were redefined, their power and responsibilities were redistributed. The creation of new elite techno-financial institutions and restructuring of center-state relations, because this authority that was set up was a centralized authority, and it took a lot of negotiating with state governments to also have state-level authorities set up. And this went through a very protracted parliamentary process, which was outside of the courts, and that's an interesting story in itself. The creation of these new elite techno-financial institutions and restructuring of center-state relations by the judiciary through the single case on forests is illustrative of the reshaping of federal relations of governance to accommodate what can be called green neoliberalism. So you see the sweeping changes that have been made by this case at the institutional level, at the level of understanding of forests, and at the level of who has access to these resources. Now, so clearly, there have been a lot of reaction, and there's been a lot of writing on what have been the implications of these legal changes on the ground. The Godavarman case continues even now, but of course not in the form and shape that it had been going on for those years when it was at its peak of activity. In 2015, the bench distributed its cases and sent a whole bunch to the NGT, and those related to wood-based industries and state governments, and some policy matters to the MOEF. So the Godavarman case still looks after a whole bunch of cases, but not as many as before. But the implications of what was done by the Supreme Court with respect to compensatory afforestation and net present value has actually unleashed a whole set of dynamics on the ground. Like, for example, there are scholars who said that this was basically this process of putting a monetary value on forests, but not coming up with any mechanism by which to stop the extractive use of forests, basically meant that it was a pay and convert approach. Yeah, many social movements who also work on forest rights have called it a form of licensing deforestation. In fact, in 2014, there was a very interesting article that came out, and this was when the Central Empowered Committee was being changed. The composition of the Central Empowered Committee was being changed, and one of the officials who worked for a mining conglomerate basically said that unlike what a lot of people think, the Central Empowered Committee actually was not a roadblock for mining projects. In fact, it was a road opener for mining projects, basically saying that this form of monetizing of forests and making procedures clear for how forests can be accessed by people who need them for mining and those kinds of projects, it had basically simplified that process, or at least made it clear that a payment would result in the approval. Basically, what this has meant is that because of the collection of funds in the name of compensatory reforestation and net present value, a lot of funds have now become available basically for the forest department to go back to an earlier form of heavily funded plantation forestry projects. And there are already a number of reports about how plantations are being taken up in regions and in areas where Adivasi communities have claims over these forest lands through the Forest Rights Act, which came up in 2006. In fact, scholars have even stated that it is because of the form of environmentalism that the Supreme Court, adopted in the Godavarman case, that the Forest Rights Act even became necessary. Because basically, on the ground, the process of making claims and the process of obtaining legal rights over forests became even more difficult because a large number of forests were now being handed over to different kinds of projects, projects like mining projects and others. And another aspect that is interesting to understand also is that the money has created a lot of pressure to create compensatory afforestation plantations in different places. As we already know, the initial reason why compensatory afforestation had been a failure was also because land for plantation was becoming very difficult to find, and that issue continues even today. And so there are a lot of karyakartas on the ground who look at Forest Rights Act and who look at how forests are being handled, say that there are a lot of ghost plantations coming up. Basically, these are plantations that are only on paper and you don't see them on the ground. In many areas, forest departments are actually trying to create plantations in places where forests will never grow. Like, for example, on riverbanks, sandy riverbanks, or on common lands, which are mostly grasslands, and areas like that. So it's really important to understand this idea of, or this effort of the government to create compensatory afforestation or new forests in different places. But both human communities and ecology and forest species are not likely to be obedient to the government as and when, in terms of where they should be put up. So you see that forests don't really grow everywhere, and so the government makes these failed attempts at doing compensatory afforestation in places where it's not at all viable. So the pressures to take up the pressures to grow plantations in different places has led the government to different state governments to come up with, to create what are called land banks. Basically, these are lands that the government takes in advance so that when it has to do compensatory afforestation to comply with the procedures of the Forest Conservation Act, they have a ready supply of land. And this creation of land banks is actually being resisted in various places, especially where communities have claims over these lands through the Forest Rights Act. I'll stop here and maybe we can take some questions.
Hi. Yes. So, first of all, we have a question from one of our professors. Saurabh Bhattacharya sir asks, do you see the CA-MPA as an institution that is flawed in its conception, or do you think there are ways in which the processes and institutional framework of CAMPA can be democratized?
Yeah, I, I, I think it's both. It's certainly flawed in its conception. I feel that the diversity of forests and the range of claims and historical claims that there are on forests cannot be accommodated by a system that we have right now, because these claims were all kept outside of the discussion that took place in the courts on compensatory afforestation and net present value. And I think we'll have to completely rethink all of these concepts and definitions and ways of measuring and things like that if we want to actually bring all of those into and include all of that in the process. But I do feel that by democratizing it, even at this stage, maybe some of the negative impacts that are taking place on the ground when forest departments try to implement these projects, those can be managed to some extent.
Okay, the next question is from Harishankar Raghunath. He asks, would it be true to say that many attributes of organic forests, such as wildlife, certain geography, specific species of plants, etc., cannot be transplanted over through compensatory afforestation?
Yeah, I think this is true. I feel that we're being too ambitious or naive, in whichever way we want to look at it, to try and recreate forests, which is why a lot of people have criticized this system as and said that these are new kinds of forests, these are new kinds of products that are being created by a system that basically does not understand diversity and how forests are not just a natural entity but a socio-ecological entity. I mean, it's the relationship between forests and people that actually make both. And so it's not possible to actually just substitute what you've lost in some other place. And plus, there's also the issue of geographies. I think it's difficult to find conditions which will allow for the recreation of what has been lost. And so it's very important to actually look at what it is that we're losing before trying to recreate what is lost.
The next question is by Arushi Mittal, and she asks, would you say that judicial interventions in the area of environment have been satisfactory, and has the institution of the National Green Tribunal been helpful at all?
Well, that's a big question. I think there certainly have been some issues that the courts have taken up, which are important. But a lot of people who work on something as on forest governance do feel that a lot of these discussions should actually take place outside. That until these issues are discussed openly outside of courts and in a democratic way, and in a way that different groups of people actually understand this and relate to it and think about it differently. Unless those are discussed together, it's not really possible to come up with a way of living with forests, or some form of coexistence that works for everyone. Unfortunately, even though we do depend on courts to actually, play the role of mediating, but sometimes, especially like, for example, in the Godavarman case, it's been very top down, and it's been very instructive, and that doesn't necessarily work on the ground when you try to put these things into practice.
Okay, I think we'll take one more question. This is by Ketan Jain. As you mentioned, the concept of green economics has become quite the rage in the field of legislative economics. However, many economists remain ambivalent about its efficacy. So basically, perhaps he's trying to understand the future of green economics and how that's
Yeah.
going to play out in the future in India.
Yeah. I think it's an amazing field, and it's really growing, and there's lots of people sort of working and speaking about ecological economics. And I think even in the context of climate change, they see it as a huge challenge about how economics would actually sort of respond to these massive, almost survival challenges. So it's an interesting field. But at the same time, it's a field that is rife with debate. I mean, there are so many discussions and viewpoints which are still very difficult to, sort of, tie up and close. Luckily, that's not taking place. That's not happening, which is a good thing. But a lot of this is actually also happening in academic circles, and policymakers, invariably policymakers need something which they can immediately apply to policies. And so that's where the issue becomes fraught with a lot of problems. You can't just pick up a concept or a framing in a field that's as large as environmental economics and just apply that to policy. At best, what should be done is some kind of pilot projects to see how they play out on the ground, what kinds of challenges they throw up, how do people respond to it. I mean, those are the kinds of things that could be done, but you can't pick up anything from sort of an academic field and just apply that to policy.
Manan, just one more doubt that I had. Just picking up right from the lecture only. Could you once again, like very briefly, clarify about how NPV was implemented in India? Keeping in mind the many complexities surrounding the existence of different kinds of forests, and you had pointed out.
Yeah.
So again, just clarify a little bit about that.
Yeah. So basically, when a project comes, when a project requires to use forests, they basically have to pay this amount, and somebody in the forest department sits down and figures out and calculates what is the value of the forest that is being lost, and what is the amount that needs to be paid by the project for taking over that amount of forest and for converting it into something that is not a forest. So basically, these are net present values, basically a payment that has to be made by whoever wants that forest area to set up that project. And now, because there is a centralized fund, that payment goes to the centralized fund. That's how that fund has grown into a fund that has more than 90,000 crores now.
Okay, thank you for answering these questions, ma'am. Actually, we would really like to know about the project that you are currently working on and that Namati has currently been working on. Would you like to share some
Yeah.
details about that?
So,
Yeah.
so Center for Policy Research and Namati have a collaboration, and we've been, implementing this project called the Environmental Justice Project. The project basically since 2012. The project basically looks at cases of non-compliance. So many of these environmental laws are basically set up procedures where development projects can obtain permissions or approvals or clearances from the Environment Ministry or state environmental departments. So it could be approvals for large projects, or it could be consents from the Pollution Control Board and things like that. So there's a certain framework that all of these laws seem to have, and they're all approval-based procedures. Basically, these are procedures meant to give approvals to projects. But all the approvals invariably have certain conditions that are attached to them. And so through this project, we were basically interested in looking at what happens to these conditions, who actually monitors or supervises these conditions, because the conditions are actually really crucial for communities who live around these projects. So, for example, you can have conditions like a project that is giving out dust or fumes should have a tree cover around it so that people outside of that are somewhat protected from these impacts. But we never knew until we started this project. We didn't quite know how these conditions are monitored and what is the status of these conditions. And so we basically, through this project, we basically conduct research on how these compliance-based conditions are actually implemented on the ground.
Thank you for joining us, ma'am. Now we will be joined by our the NUJ's Legal Aid Society's faculty advisor, Ognidipto sir, who will be here with us.
Hello, good afternoon, everyone. Thank you for joining in through the lecture. Thank you particularly to Ms. Menon for taking time out of her busy schedule to be with us today. And I think it was a very enlightening lecture. I personally learned a lot in terms of the interdisciplinary approach that people working on the intersection of law, environment, policy making, etc., have to grapple with every day in trying to understand the complexities of a subject on which our common futures depend. So, to all the law students who have joined in to today's podcast, I think you'll be very, very happy to have heard someone who has worked and has so much of experience in working on the intersection of these areas, and also to appreciate the amount of interdisciplinary work that is required to try and understand these thousands of environmental regulations that this country today has and is grappling with. So thank you once again, Ms. Menon, for taking time out for this lecture. I'm absolutely certain, as I'm sure the audience will agree, that there is a lot to be gained from this, and I'm sure that lectures such as these will also encourage them to pursue careers in environmental policy. To my friends and students in the Legal Aid Society and EJS for organizing this on reasonably short notice, thank you again very much to Sushovan, to Dev, Ketan, Simran, and all the others. Good job, guys. And to the audience for tuning in on a Sunday afternoon and giving us your time. I'm sure we've all benefited from this greatly. Thank you very much and have a good day.
Thanks. Thank you.